Let's go ahead and talk about the differences between civil and criminal enforcement. The main differences fall under three categories: legal standard, burden of proof, and results. Environmental civil liability is strict. It arises simply through the existence of the environmental violation. It doesn't take into consideration what the responsible party knew about the law or regulation they violated. Environmental criminal liability is triggered through some level of intent. As a result of this distinction, most of the environmental criminal enforcement that EPA investigates involve knowing violations of the law. These are classified as felonies in all the federal environmental statutes, except for the toxic substances and pesticide statutes. In a knowing violation, the person or company is aware of the facts that create the violation. A conscious and informed action brought about the violation. Examples of knowing violations include an intentional decision to dispose or dump pollutants into a river without a permit, or to not install a required air pollution control device. In contrast, a civil violation may be caused by an accident or mistake. Remember, the liability is strict, meaning the person is automatically liable if they violated the terms of the law. To be found civilly liable for violating environmental laws, the standard of proof is based upon the preponderance of the evidence. This means that the evidence presented is convincing and more likely to be true than not true. Effectively, the standard is satisfied if there's a greater than 50% chance that the evidence is true. Criminal guilt must be established beyond a reasonable doubt. This is a higher or stricter standard than the civil liability standard. When a criminal defendant pleads guilty or is convicted by a jury, there's no question of legal wrongdoing. He or she has legally committed the crime. The defendant in a civil suit can either be found liable following a trial or reach a mutually agreed upon settlement with the government. Under a settlement, the defendant is required to meet all of the terms of the settlement, but does not have to acknowledge that he or she violated the law. If a civil defendant is found liable or agrees to a settlement, the result can be a monetary penalty, injunctive relief, actions required to correct the violation and come into compliance, for example, installing pollution control equipment, and or additional actions taken to improve the environment. If a criminal defendant is convicted or pleads guilty, the result can be a monetary fine paid to the U.S. Treasury and or restitution or incarceration. There are three types of enforcement actions. Civil administrative actions. We discussed these in the introductory module. Civil judicial actions and criminal actions. The latter two will go into more in-depth in the legal cases. Civil administrative actions are non-judicial enforcement actions taken by EPA or a state under its own authority. These actions do not involve a judicial court process. This could be in the form of a notice of violation or an order directing a business to take action to come into compliance. Civil judicial actions are formal lawsuits. They're filed in court against persons or entities that have failed to comply with statutory or regulatory requirements, comply with an administrative order, pay EPA the cost for cleaning up a Superfund site, or commit to doing the cleanup work. Criminal actions can occur when EPA or a state enforces against a company or person through a criminal action. Criminal actions are usually reserved for the most serious violations, those that are willful or knowingly committed. A court conviction can result in fines or imprisonment. These cases are filed by the U.S. Department of Justice on behalf of EPA. Let's take a closer look at the possible outcomes of both civil and criminal enforcement actions. Under civil enforcement, there are four possible results. The first and most common are settlements. These are generally agreed upon resolutions to an enforcement case. Settlements and judicial actions are in the form of consent decrees signed by all parties to the action and filed in the appropriate court. And are civil penalties. These are monetary assessments paid by a person or regulated entity due to a violation or noncompliance. Penalties act as an incentive for coming into compliance and staying in compliance with the environmental statutes. Penalties are designed to recover the economic benefit of noncompliance and to compensate for the seriousness of the violation. The third possible result is injunctive relief. This requires a regulated entity to perform or refrain from performing some designated act. It also brings the entity into compliance with environmental laws. The fourth possible result is a supplemental environmental project. These are fines or an environmental improvement project that a violator voluntarily agrees to pay or perform. These projects are in addition to actions required to correct the violations specified in the settlement. Supplemental environmental projects are popular because they can fund lots of popular programs. For example, the Volkswagen cheating supplemental environmental project resulted in millions distributed to states to implement projects to reduce vehicle emissions. During my time at EPA, ASEP funded a large school bus retrofit program. Under criminal enforcement, there are two possible results. The first are criminal penalties. These are federal, state, or local fines imposed by a judge at the sentencing. Or the defendant may be ordered to pay restitution to those affected by the violation. For example, a defendant may be ordered to pay a local fire department the cost of responding to and containing a hazardous waste spill. The second is incarceration. This refers to prison time for an individual defendant. Criminal penalties are particularly severe for knowing violations that endanger human life. For example, the Clean Water Act provides penalties of up to 15 years in prison and fines up to $250,000 for violations